Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Good morning, everybody. Thank you for joining us today. Our topic is business strategies for real estate investors. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like, subscribe to our channels. You can find us on Facebook and YouTube. At YouTube, it is at INREM Podcast. That is at INREM Podcast. Make sure to follow us. We would greatly appreciate it. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So today I want to talk about insurance for subject to transactions. So I receive a lot of questions on insurance, like, hey, I'm going to purchase this property subject to, or maybe I've already purchased this property subject to, what am I going to do on insurance? And honestly, there's a number of ways to structure it. Some will cost you a little bit more, but I believe there's a proper way or a recommended way to do it. And that is to basically for the buyer, so the new owner, to go and procure their own insurance from a insurance agent of their choosing, preferably somebody who understands a subject to transaction and real estate investing, and they procure the insurance in their name as the insured and as the property owner. Then from there, they go and they list the seller as an additional interest. So not an additional insured, but an additional interest, so that the seller name is showing on the policy as somebody who is an interested party, has some form of, interest in the insurance policy and the property. Now, their interest would be through a wrap transaction or things like that, or the fact that they're still the borrower under the existing loans. But you list them as an additional interest. And then from there, you list the existing lender as the loss payee under the policy. And so that's how, in my view, and my recommendation to properly structure it is to list the buyer as the insured, list the seller as the additional interest, and then list the existing lender or lenders as the loss payee or payees. Then from there, you cancel the seller's policy and you submit the new policy to the lender. And that's the policy that's then paid by the lender from the escrow funds that accrues through the monthly payment that's made on those existing loans.
Why don't you explain for the listener? I think it's important because insurance, when they hear insurance, it sounds boring, it sounds dull, and it's like, well, maybe I'll figure this out, or maybe I'll forget to. I'm not too worried about it. What are the implications for failing to do this correctly?
Yeah, so there's a couple of implications. So number one, if you do it incorrectly, and you just leave the seller there as the insured, then when there is a loss, the insurance company is, no matter what you have signed by the seller, frankly, the insurance company is there to mitigate their risk. So they're looking to pay the seller because that's their insured. And then you're now forced to rely upon documents that were signed that are good documents, that are helpful documents, like an assignment of insurance proceeds, to obtain the funds from the seller, or to be able to use the funds to repair or improve the property that was damaged by a water loss or a flood or other casualty, right? So now it's a major problem and imposition, and you're having to do a lot of extra work and secure the cooperation of multiple parties in order to simply repair property that is yours. So that's number one. Another strategy that I've seen employed is where the seller's policy remains in place, and then the buyer goes and obtains their own policy as an insured. And in that case, the buyer is paying extra, right? So every time that they make a monthly payment to the lender, there's a portion that's going to escrow to pay for the seller's policy. And then the buyer's paying separately for their own policy. So they're paying double for insurance, number one. Number two, when a claim is made, well, insurance companies are always looking to see, who else is out there, right? There's this term called subrogation, like who else can I recover from?
Right.
And so you're going to end up with the seller's insurance company looking at the buyer's insurance company and saying, hey, look, you need to pay. And the buyer's insurance company is going to then look at the seller's insurance company and say, no, you need to pay. And now you have two insurance companies looking at each other saying, no, you need to pay, and nobody's paying. And yet you have a property that's been damaged or destroyed that needs to be repaired. And you can't convince either insurance company to step up and pay because they think the other one should be paying. So it is critical and important to do it and do it right. And that's why I believe that the proper way and the best way is to put the buyer as the insured with the seller as the additional interest, and the existing lender or lenders as lost payee or payees.
All right. Thank you, Sean, for the legal update. Let's talk a little news. So INREM just held its first Creative Finance Symposium last Thursday, and that was a great opportunity for listeners to learn more about creative finance, to hear from Sean, to hear from I about particular subjects. But it really was an important opportunity for listeners to really have live access to us to ask questions and discuss that. And we had folks that attended from all over the country. It really was a good event. We'll be holding that again March 9th, Thursday, March 9th, from 6 to 7 p.m. Sean, why don't you tell the listeners a little bit about what to expect and kind of the format that we're going with that?
Yeah. So the next Creative Finance Symposium will be all about the due on sale clause. So, we hear this thing out there on due on sale and people talk about the due on sale, but I've honestly never seen anybody take the due on sale clause and break it down. What does it actually say? Now, there are many types of due on sale clauses. They have a different language. So we're going to be taking a sampling of, 3 or 4 different due on sale clauses that you're going to find in deeds of trust, whether that's an FHA loan, a VA loan, a Fannie Mae, Freddie Mac, or even a private loan. And we're going to go through and we're going to break down the language of those due on sale clauses. And that's going to be the first half an hour. The second half an hour is going to be an open discussion that those in attendance can pose questions in the chat feature of the symposium, or they can raise their hand and we will unmute them and they can ask the questions, they're live to us. And look, I'm going to be a little frank with our audience here today and say, hey, look, I constantly am being tagged in social media, sent messages, by social media, sent emails, even some phone calls, saying, hey, can you just answer a quick question, or do you mind, chiming in about this? And, to sit there and write a response takes me a significant amount of time for a well-reasoned response with all the right disclaimers. And, you're talking 30 minutes of my time versus, you and I can answer a question in 2 or 3 minutes, right? So you and I make ourselves available no less than 7 times during any given month to answer questions. The Creative Finance Symposium is one where we're there for a half an hour. You can ask us anything regarding creative finance. And frankly, you could ask us anything about real estate investing if you want to. Last week we had somebody talking to us about wholesaling and asking some questions about wholesaling. We're available. And so, if you're not taking advantage of this opportunity to discuss these legal topics and these legal issues, you're missing out. This is your opportunity to have us captive, if you will, for a half an hour to basically chime in and say, hey, I have this legal question, or, can you give me this information on this, legal topic? And we're there and we will answer the question. So frankly, if you're not plugging in to the Creative Finance Symposium, attending it, asking questions, you're missing out. And instead of trying to get us to write a response on social media or something like that, you're going to have a much better opportunity to join this symposium to attend live and ask your question. And there's other opportunities. In fact, you're going to go into another one here in a few minutes where tonight people are going to have a chance to ask us questions. And on the show, people have a chance to ask us questions. So like I said, no less than 7 times in any given month, you and I are available to answer questions live from people. And as they just need to participate. That's it. Bottom line, just participate.
That's it. Thursday, March 9th, 6 to 7, every other Thursday, the Creative Finance Symposium. Make sure to be there. That's your chance to have us captive, as Sean says. Also tonight, the buy and hold meetup starting at 4 p.m., at least the marketing portion, and our show will begin at 4 p.m. That is taking place live at the Scottsdale Area Association of Realtors. And on top of that, you're speaking at this one, right, Sean?
Yeah. So basically the topic is creative financing. I'm going to be a presenter with Eileen Brown of American Title Service Agency, who is an experienced branch manager and escrow officer with creative financing subject to transactions. And so you're not going to want to miss that. It's as you said, at the Scottsdale Area Association of Realtors. It starts at 4 o'clock. It's from 4 to about 6:30. And the first portion of the event is us live from 4 to 5. And guess what? We're going to be answering questions.
We're there.
We're answering questions. So if you show up to the event, you can sit with us and we will say, hey, what's your, legal question or issue? We'll provide, try to answer it to the best of our abilities. Obviously, it's not legal advice, those types of disclaimers will go with it, but nevertheless, we'll do our best to provide some guidance. The other thing people can do is similar to what they can do with the show. Put in the feed for the event, put in your comment or in the comments, put your question down. So if you're watching online, that doesn't mean you can't ask a question. Put it, in the comments section. And if we have time, we'll look for those comments and we'll answer them there at the buy and hold tonight. And it can be about anything real estate related. Just put it in there and we'll do our best to answer it. So once again, it's your opportunity to participate, to ask us questions and have us answer those questions, in this live event. And then my presentation, mine and Eileen's presentation will start, probably around 5:15, 5:30. And we're just going to talk creative finance. I'm going to go through and break down some of the key clauses in my creative finance purchase contract, subject to addendum, talk about, different ways to structure creative finance transactions. So you won't want to miss it. There will be a lot of good information, a lot of good networking that takes place. So come show up. If you can't show up, watch us live, post your comments if you have questions, and we'll hopefully be able to get to those.
All right. And speaking of questions, today we'll be taking questions from you, the audience. We're setting aside, like every episode, the final 15 minutes of the show to address any questions if there are any. Mayu, why don't you explain to the listener how they can go about posting questions?
Yes, thank you. Thank you for everyone who is watching the NREM show live with us today. And yes, as Andy said, we are taking questions about 10-15 minutes at the end of the show to answer any questions you may have for us relating to today's topic. We are monitoring the live chat, so if you have any questions throughout the show, whether you're watching us from the NREM YouTube or our Facebook Live, you can drop your questions in the chat and we'll get to it at the Q&A at the end of the show. So let's talk business strategies for real estate investors, Andy.
All right. Thank you, Mayu. So as you may recall, if you watched last week, we talked about estate planning for the real estate investor. Alluded to this topic a few times, differentiated a few things, but the topic today is business and asset planning for the real estate investor. So let's get right into that. Notice the topic is business and asset planning. Those are two different things. Sean, what is the difference? How would you define the two of those and differentiate the two?
Yeah. So asset planning is basically creating a clear separation between personal assets and business assets. That's what asset planning is. So the idea is that you operate your personal affairs out of your personal bank account. You have your personal residence that's either in your name or in the name of a trust, as we suggested last week. And you have the homestead protection there. And you basically operate your personal assets as that, your personal assets. On the other side of things, you have your business assets. So you create the separation by forming some form of entity, and limited liability company, a corporation, and they operate and handle the business side of your life. They handle your business affairs, if you will. And you put your business assets in those entities. So for example, if you own an investment property, you would put it into an entity, and that entity would then operate the business. So if you have a tenant in the investment property, the lease would be with the tenant, would be in the name of the entity. It wouldn't be in your personal name. The leases with the entity, the payments that you receive go to the entity. They're put into a checking account for the entity. The entity has its own EIN or tax identification number, and it's going to file its own taxes. And everything you do, you're going to business related, you're going to do it through an entity. And the reason is because the entity is its own thing, separate and apart from the individual owners. It's its own like being almost, but
it's its own person in the eyes of the law.
Yes, in the eyes of the law.
Yeah.
It's but the key is to create that separation. So what does that mean? So let's say you have an investment property and you're good about putting it into an LLC. You have a checking account for the LLC. You have an EIN. The lease is signed in the name of the LLC. The deed is in the LLC. Everything's in the LLC, and you run everything through the LLC. You don't put any of your personal assets or anything like that into that LLC bank account. Or if you do, you document it as a loan or a capital contribution. But you create that separation. And let's say, God forbid, somebody goes onto that property or a tenant's in the property and they manage to somehow electrocute themselves and they're seriously injured or dead as a result. Well, that's pretty big tort claim potentially that they have against the property owner, potentially, depending on the nature of, if there was a defect or problem with the wiring or things like that. And so who's subject to the lawsuit? Well, it's the entity, it's the LLC. So the only asset that's on the hook in that case is the property. Your personal assets, your personal home, your personal bank account, your retirement, although there's exemptions there, but your retirement, your personal property, your vehicles, none of that's on the hook because they're all in your personal name. And you've created that separation so that the only thing that would be liable is the LLC, the entity, and the only asset presumably that the entity has would be the real estate. So the only thing that they could do is potentially take the real estate. Now, what happens if the real estate has a bunch of loans against it? You've bought it subject to. Well, good luck. I mean, there's not much there, right? So now you're stuck just relying upon whatever insurance coverage was available. So that now I'm going to show another scenario so you can show you can also see the importance of asset planning, which is, what if you have this LLC that's operating and you're driving to the store to get milk, and God forbid you blow a stop sign and there is another car there and you hit them and you seriously injure them, potentially a big tort claim again. Well, the lawsuit, once again, is who's the lawsuit against? Well, you weren't running to the store for business. You were running to get milk, right? So you're running a personal errand.
Right.
So the only thing that's on the hook is your personal assets. The judgment is against you personally. It's not against the LLC that owns the property. The LLC is not subject to a judgment because you weren't doing anything for the benefit of that. You weren't acting in a business capacity in going to the store and in obtaining milk. So those two examples illustrate the significance of the separation between personal assets and business assets. And that ultimately is asset planning. So now what is business planning, right? So business planning goes beyond that. That involves, okay, how do I structure my entities to take advantage of tax benefits, to make it easier to operate, less cumbersome, obtain loans and financing. And so, you're looking at, maybe having a holding company, and then your real estate is held only in partnerships versus, let's say you have a wholesale business that could be run through an S corporation, but it's flows outside of the partnership taxation that holds real estate, but it all ends up into the trust. That's business planning. You're working with a CPA, with an attorney, to say, okay, how do I basically have three things? How do I plan my estate? So when I die, who receives my assets and how does that go smoothly? How do I structure my business to obtain asset protection? And then how do I avoid taxes? And then finally, I guess there's a fourth thing. How do I make it so it's as simple as possible? Those are the four things you want to do, right? That's what you're looking for. And so you're working with a CPA and an attorney to bring all that together and plan your business. So that's business planning. It's basically a higher level than just a basic asset planning. Basic asset planning is LLC, person. Business planning is more of a holistic approach to everything that you do business-wise.
Yeah, it seems to me that asset planning is much more about liability protection, about just divvying up your assets and protecting them, and properly structured, where business planning is much more similar to what you do on an individual level with estate planning, right? And how to do that. So let's talk about how we set this up on the asset planning side of things. And that usually looks and involves the formation of entities. You just mentioned that in your description before, and how to do that. In every given state where there's a host of just options that can be done when it comes to entities. The corporation is the oldest form of it. Partnerships and sole proprietorships are old forms of it. Maybe the newer form of of an entity structure is the limited liability company. What do you like in terms of here in Arizona? What do you like to use in terms of an entity for asset planning perspective?
So my preference here in Arizona especially is the limited liability company instead of a corporation. And there's a number of reasons why I like an LLC. The biggest is that with an LLC, you can form it and forget it. And what I mean by that is there's no regulation in Arizona that you have to file an annual report, that you have to renew your filing. If you say that the LLC is going to last in perpetuity, which anytime I form an LLC, I state that. There's no reason to state otherwise generally. So you say it's going to last in perpetuity. That's it. There's nothing more to be done. There's no fee to be paid to the Corporation Commission. There's no annual report to be filed after it's formed. Nothing. You basically create it, file it, and forget it. Versus a corporation, every year you have to go and file an annual report with the Arizona Corporation Commission and then pay a fee. And if you don't, the Corporation Commission will administratively dissolve the entity. I've had clients who they come to me for one reason or the other, generally real estate. They're like, okay, I want to buy this piece of real estate in this corporation that I have. For one reason or the other, they used a corporation. So I'm like, great. So we start doing our due diligence. And of course, one of the first things I do, I jump on the Corporation Commission to confirm, who can sign on behalf of the corporation and the status of the corporation. Sure enough, and this happens, it happens more than it should. I get on there and I look and I'm like, this has been administratively dissolved. It's not even an actual thing anymore. I mean, it's not supposed to operate. Now, sometimes it's an easy fix and you file all the back annual reports and pay a bunch of fees, or alternatively, it's about to be administratively dissolved, and then we have to pay late fees and all that good stuff and file annual reports. But the client had no clue. And the reason why is because It used to be that the Corporation Commission would mail out a notice and say, well, they don't do that anymore. They do email here or there,
Right.
but they don't have to. It's not a requirement. And for a while there, to save money, they weren't even sending emails. It was just like you calendar it and you file it. And if you don't, tough luck, we're going to administratively dissolve your corporation. So I don't like corporations for that reason here in Arizona. Limited liability companies are, in my view, the way to go.
Well, and that speaks to why historically limited liability companies were created. The corporation is the older form of entity. It's not that it's a better or worse form of entity. Both give you the liability protection that we'll talk about in a little bit, and they both do that well. But a corporation is a very rigid structure. And this is, I think, what you would find is pretty typical in maybe all of the states, that the corporation is a rigid structure. You don't have a lot of flexibility in with it, how it's run, how it's formed. You're going to have a board of directors, you're going to have shareholders, you're going to have officers of the corporation. And that all sounds fine and good, right? Until you're a mom and pop restaurant who's just, John Doe and Jane Doe. And they're like, why do I need a president? And why do I need a vice president and a secretary and a treasurer and all these kind of things? So the idea behind the limited liability company was to provide options. And that's what I think made the limited liability company so popular. You can run it rigidly if you want. In a limited liability, you can elect to have a board, officers, all those kind of things, or you don't have to. So let's talk a little bit about the difference in kind of the management structure. Almost nobody I ever run into opts to run their limited liability like a corporation, though they could. How do you see most of them set up the management structures of their LLCs?
Yeah. So LLCs have members and not shareholders. So corporations have shareholders, which means now a lot of times they don't issue it, but it wasn't too long ago that most corporations would go and actually obtain a seal, and they would create stock certificates and provide it to the shareholders, where you actually own a stock certificate for the corporation. That's essentially what a shareholder is. LLCs don't have that. They have members, and members own a percentage of interest in the company. So, you could own a 1% interest, 100% interest, or anything in between, or even as, 0.1% or even smaller interest, and anything in between. So, but it's an ownership interest. It's a percentage of the interest in the company. So there's 100% of interest in the company, and you can divvy that 100% up any way you deem appropriate to show who actually owns it. And you give that interest to members who own the company. So it's members instead of shareholders. It's percentage interest versus stock shares. Then you can structure an LLC where the members actually run it. They manage it. So that's called a member managed LLC, where they do everything. They're in control. You don't have officers, you don't have directors, and you don't have managers. You have members who run the day in and day out affairs of the LLC. However, you can also create what's called a manager managed LLC, where the members own it, but the day in and day out affairs of the LLC is run by a manager who has certain powers, either provided by our laws or by an operating agreement for the company. And the manager basically runs the company. They may or may not own it. Sometimes members can also serve as the formal managers. Other times it's the members own it, and then you have third parties that aren't owners, that have no interest in the company, except the ability to manage it, who manage the company. And so you don't have officers for LLCs, you have managers. Unless you choose to, like you said, you can choose to have officers, but normally you don't. You just have managers or members that run it. The other thing is, like you said, with the flexibility that LLCs provide, is you can make tax elections the same as you would as if the LLC were a corporation. So you can elect to have an LLC taxed as an S corp, as a C corp, as a partnership, or depending on ownership as a sole proprietorship. So if it's a husband and wife that own it, they can have it taxed either as a partnership or sole proprietorship, or if it's just one individual that owns it, they can have it taxed as a sole proprietorship. But you can also elect the corporation tax designations as well. Versus a corporation, it's either going to be taxed as a C corp or an S corp. And so there's a lot more flexibility with LLCs. And this is very important too. If you're ever discussing with your CPA or your attorney and you say, oh yeah, let's form or create an S corp. The attorney and CPA are more than likely are not thinking that you're going to form an LLC and create it and make it an S corp. But I've had clients who have been like, oh, well, I need to form a corporation. So they form a corporation, and now you have all the issues that we've talked about with corporations that have to be dealt with. And, instead of an operating agreement, you have bylaws and partnership agreements instead of or shareholder agreements instead of a buy sell or things like that. And it's more cumbersome to operate a corporation. And so you're like, oh, well, I didn't mean, go form a corporation. I meant we'll do an LLC as an S corp. So just keep that in mind. If a professional you're working with says, oh, let's do an S corp, don't just assume that means you need to form a corporation. Clarify and say, you mean an LLC taxes an S corp. Don't make that mistake. And also professionals need to be a little bit better when they, make those recommendations to make sure their clients fully appreciate what's going on there. So yeah, those are the main differences and the main, operating features of an LLC.
So once we've got the entity formed and we've decided on that, of course, we've done this because we've met with a lawyer and they said you need to protect your assets from liability. So what does that look like in terms of corporation law, limited liability company law? There's this thing called the corporate veil, or a veil of protection that's afforded. And that really means, in Arizona, the limited liability statutory references states something like, the individual owners are not obligated for the debts and obligations of the company. In other words, the law is treating this company as its own person. So if this company contracts with other companies or does certain things, it has its own liability. Of course, that seems a little confusing from the perspective of, well, how does a company act outside of the individuals itself? How does that work itself out? But as a general rule, the law provides this corporate veil so that people that are seeking or have been injured can't pierce this veil, go through it, and go down a layer below and go after the owners. All right, so that sounds great. So then the question is, what is stopping me then from setting up all of these entities and doing whatever I want through them? Am I always individually protected? Is there any way that corporate veil can be broken, or as the law refers to, pierced? Is there any way to go through that and get to the owner, or can I just set up an LLC or a corporation, act through it, and do whatever the heck I want, and I'm good to go?
Yeah, great question. So the answer is, yeah, the corporate veil can be pierced, and you have to be very careful how you operate entities so as to avoid that from happening. And there's really three ways that you can pierce the corporate veil and pursue the individual owners for the debts and obligations of the entity. So the first, and this is one that's not rarely discussed, or is rarely discussed, and frankly, I've only seen one lawsuit brought where this was alleged, but it's undercapitalization. And that's where somebody creates an entity knowing that the entity is about to go out and engage in some risky endeavor, and they do not have the funds to back it up. It's undercapitalized, meaning if things go, that this is a risky transaction, maybe it's you're soliciting investors for multi-million-dollar commercial property, or maybe this is a situation where you're going to be taking on lots of debts and obligations of the company, knowing that, at some point, if the project doesn't work out, you're going to have to repay these debts and obligations, and you don't have the money to back it up. There's not money available to cover these, debts and obligations, the loans. And so undercapitalization is one. Once again, it's rarely pursued, but it is available by law to a creditor of the limited liability company that would allow the creditor to pierce the corporate veil, say, hey, look, you went out here, engaged in this risky transaction, and you knew you didn't have the money behind the scenes to back it up. And therefore, we want to go after you personally. The big one, though, right? This is the one that we hear all the time, which is alter ego or failing to maintain corporate formalities. And that gets to your point. Well, like, can I just do whatever I want? No, you can't just do whatever you want. You have to keep corporate formalities. And we talked a little bit, or I mentioned some of the things that you would do to keep those. Number one, the entity would have its own tax identification number, or an EIN. It would have its own bank account. It would keep separate books and records. And you wouldn't commingle assets. Now, this is also important for business planning and structuring. Part of that is asset planning. Part of that business planning is asset planning. And it's creating separation not only between personal assets and business assets, but true business planning is creating a separation between business assets and business assets. So you might have multiple businesses that you operate, and you want to protect those. So if any one business has exposure, the other businesses aren't going to go down with it. And so you create that separation. Well, when you commingle funds, we're not just talking personal assets to business assets and commingling personal and business assets. We're talking commingling business to business assets. So, you should not be basically pulling money from, this business's bank account over to this other business to basically keep that business afloat. There's a process of how the money's to flow. And so the money should then flow from, the businesses to the owners. And then if another company needs, money to operate, then the owners infuse capital as a capital contribution or loan. Now, could you properly document business to business loans? Yeah, but they should have.
Nobody ever does that. That's the first problem.
Right. And they should be legitimate loans, right? It should be like, hey, a reasonable interest rate. What would a lender normally charge this business for this loan? And then repayment should be made. And if repayment's not made, then steps should be taken to enforce that. You know what I mean? So that's keeping corporate formalities. Like, is this business operating like a legitimate business?
This is, I think, particularly easy to have happen in, just speaking of real estate investment type stuff, in construction projects, right? Where you got multiple going on, a whole bunch of, maybe, here's the other problem, right? You might have multiple deals going on with multiple entities, but you know how real estate investors work. They've got their people, they've got the contractors they like working with, they've got the tradespeople that they liked working with. So a lot of these same people are working on maybe 5 different jobs, but these are jobs all for different entities. So you can just see how easy this would be. A lot of this isn't malicious. A lot of this is just accidental and easy to do.
Right. Yeah. It's just sloppy business practices. I get an invoice from this contractor and it lists 5 jobs. Well, instead of writing 5 checks, this business over here has plenty of money in it, I'm just going to write the check from there. Well, no, because now you've just commingled funds. Now you've just exposed, let's say then somebody goes out to the job site on one of those projects and somehow manages to injure themselves and there's no workman's comp to cover it. Well, who are they going to sue? They're going to sue the owner, right? Well, wouldn't they like to sue that LLC and all your other LLCs because you commingled funds? Absolutely.
Yeah.
And will they? Yeah, very well. They will. So don't be lazy. Don't be sloppy. That's what's interesting about asset planning. And I have this conversation with my clients a lot. There's this delicate balance between the practicalities of it and the effectiveness of the asset planning. The more effective the asset planning, the tougher it is to operate and the more time consuming it's going to be to operate. So if you want, like, hey, I want to make sure that every single property is, in one LLC and, I have 15 properties. Okay, well, you're going to have 15 LLCs. You're going to have 15 EINs, 15, potentially 15 tax returns, 15 bank accounts, 15 sets of books. You're going to have to do all that to maintain that structure. Do you want to do that? Or should we consider, maybe putting multiple properties into one LLC? I don't know. I mean, I don't have the answer. It's not my business to plan, but you just have to understand that the more asset protection you have, frankly, the more difficult it is to operate. And so there's this fine balance between, practical operation, time consumption, and actually, having that good asset protection in place.
So let's talk about another big one that is easy to fall into if you're really not thinking about the implications. In Arizona specifically, we call it fraudulent transfers.
Mhm.
What should listeners be watching out for there? What do the typical fraudulent transfers, at least here in Arizona, look like?
Yeah. So basically, I mean, there's a number of ways to prove fraudulent transfer, one of which is undercapitalization as well.
Yeah.
That is a factor. But really the biggest one that we see that's pursued is, back to my hypothetical, somebody goes on into the LLC and, electrocutes themselves. And let's say, hey, this LLC was doing well and there was a lot of cash flow and there's, $100,000 in the bank and 300,000 in equity. And you're like, oh boy, we're going to fix this. And you start transferring the bank account and the lease payments and, everything going forward into some other entity or into your personal name, right? Or you move the property out of that LLC into a different name. You can't do that. That's a fraudulent transfer. The minute a claim exists, you're not supposed to do that. Now, you can do it if the other company pays fair market value, but then you've infused a bunch of cash in the bank and you're not supposed to then, take that cash and drain it.
Right.
And so, or you decide, or you get in an accident, you individually, right? And so you're like, oh, I'm going to move everything out into, an LLC, out of my personal name into an LLC, so they can't get to it. Well, no, that's not how it works. The minute you have a known creditor and you start moving funds around to avoid paying that creditor, that's a fraudulent transfer. It's actually a crime.
Mm-hmm.
And so you're not allowed to do that. And if you do, it just opens the door for the creditor to come after whoever received the assets. So now you've created a much bigger problem for you or your entity, because you're trying to avoid claims once they arise, and it just doesn't work that way. That's why it's called planning. It's called planning because you plan in advance. You're not supposed to do it once there's an issue. You're supposed to plan for the event that an issue arises. And so that's why it's called planning. Because, frankly, if somebody came to me and like, hey, I got this thing, can you help me asset plan? I'm like, well, we're not planning anymore. And no, I can't help you because I'm not going to help you move money, to avoid paying a known creditor, type of thing.
I always like to think when I talk with clients about that, and like to say, if it feels cute, like when you're thinking through this and it just sounds cute, it's a fraudulent transfer. And that shouldn't be confused with other creditors that are owed money. Of course, we're not talking about bankruptcy here. So this is assuming you haven't filed bankruptcy. You're allowed to prefer creditors.
Mhm.
If you don't have enough, but you're paying one and you owe it, that's a thing. But it's really looking for like insiders where you're like moving money just to avoid creditors.
Right. To your family, to your entities that you own, things like that. Yeah.
Right.
And frankly, you and I have both seen it where these poor family members like, oh yeah, I'll take it. Like they don't really appreciate what's going on. Next thing you know, they get named as defendants in a lawsuit and they're spending all this money on attorney's fees because of course the person that transferred it to them doesn't have the money anymore. So now, they're having to pay all this money in attorney's fees, and it really becomes a major problem for the, insider, the family member that receives it. You don't want to do that to them.
Well, and one of the remedies in a fraudulent transfer action is to void the transfer.
Right.
That's why they're brought in. So yeah, you could unwittingly, because that's the other thing that happens. They don't tell the family member they did this.
Right.
I'll just go convey this real estate into cousin Jimmy's name. It'll be okay. Suddenly, cousin Jimmy's in a lawsuit.
Right.
They're like, what the heck? In any event, so let's talk about the formation of the limited liability company. This isn't rocket science here, or the formation of a corporation, but what do we need to be looking at, and what does that look like here in Arizona to do?
Yeah. So forming an LLC here in Arizona is like easy. I
Mhm.
mean, it's a matter of minutes. If you know what to do and you know what information to plug in, you can literally go online right now and put in the information. And within a matter of 10 minutes, you will have an LLC that you can operate, and you can march down, or you can go onto the IRS's website, spend another 5 or 10 minutes plugging in the information on the IRS's website, and they'll spit out for you by PDF your EIN. And then you can march down to the bank 20 minutes later and present that paperwork to the bank and open your business account. I mean, you're talking a few hours of time, and you can have a fully functioning and operating LLC here in Arizona. It's great. And so, and it's real easy. Now, a few things you have to know though.
Yeah,
'cause I
part of the
said-
problem with it being so
Right.
easy is nobody puts thought into
Nobody
it.
puts thought into it. So you have to know, okay, is the ownership going to be member managed or manager managed? And that's important because if later on you want to do an operating agreement, things like that, and you think it's structured one way, but you answered a question wrong, guess what? And I've had this happen multiple times where people come to me and, hey, Sean, can you draft this operating agreement? There's, 3 of us that we're doing it. And so-and-so's going to be the manager. Oh, okay, great. And so I say, I go on to the Corporation Commission's website. Well, they've told me somebody's going to be the manager. So it should have been formed as a manager managed LLC, but instead they formed it as member managed. So then I go and say, well, do you want to all run it, or do you still want this person to run it and be the man? No, we want this person. Well, you formed it as member managed. Oh, we did. Yeah. What does that mean? Well, that means now we need to file articles of amendment, and they're not as easy to do. It's not as easy to amend as it is to form. And oh, by the way, now you're paying us some money to do that because you probably should have us do it at that point to make sure it gets done right. And so yeah, you formed it, but it didn't really save you anything because you're basically paying us the same to amend as you would to have formed. So you're right. I mean, that's the key, is because it's so easy that they just go and put down information and then it's wrong. And then when they want to do the high level, planning or structuring, well, then we have to kind of go back to the drawing board and start over and get it set up so it's the right way.
So assuming some of our listeners listened to us last week,
Mm-hmm.
and they said, boy, great information, let's go set up a trust, and we've set up a trust. How do they need to structure their limited liability company? And I know this can depend on a lot of factors, but I think you know where I'm going. As a
Mhm.
general rule, given that they now have a trust in existence.
So if you have a trust and you say, okay, I'm just kind of getting my feet wet into this real estate stuff. I'm getting my feet wet into running a business. I just want one LLC. I just want to start somewhere, right? Okay. The way you're going to do that is you're going to form a manager managed LLC, and the member, so the owner of the LLC, is going to be your trust. And then the managers are going to be the individual or individuals that created the trust. We call those the settlers or grantors, or successor trust, or not successor, the actual trustees, the acting trustees are going to be the managers. That way, when the LLC goes and signs paperwork, because the LLC can sign paperwork, it has that legal right. You have to have an individual that signs on behalf of the LLC. Well, if it's a member managed with the trust as being the owner, well, then you have to sign, so-and-so living trust by so-and-so as trustee and so-and-so as trustee, versus if you're going to sign, it could just say, this LLC by so-and-so, its manager. And it's a lot easier to sign that way. And it makes it simpler. So that's to me, the ideal setup is manager managed with the trust being the member, the individuals who created the trust being the managers. Now, if something happens to the individuals that created the trust, they're incapacitated or they pass away, then the appointed successor trustees can just step right in and start running the LLC, because the owner of the LLC is the trust. And the trust has the right to remove managers. So the successors can step in and say, we're the successors of this trust, successor trustees of the trust. We're going to remove, the incapacitated individuals or the deceased individuals as managers. We're going to add me, the successor trustee, as manager. And then you just operate. And it's a real simple form, articles of amendment that you file with the Arizona Corporation Commission that effectuate that. So that's ideal, is how you would structure that.
Speaking of another area of the limited liability company form that's important, but nobody gives any thought to, is the statutory agent designation. This is the agent designation so that the law has a person that can be served with process if the entity needs to be sued or served for whatever reason. And I like to tell clients, this is something you ought to think about. And I always think of the pastor starting up a local church example, who decides he's going to go incorporate the church and name himself as a statutory agent. And that is, do you, as the pastor, want to be served on Sunday morning while you're delivering a sermon with service of process? And of course, the answer is no, but they never really thought about that. To what extent do you think it's important to think through statutory agent for real estate investors on when they set up an entity?
I think it's very important and often overlooked. A lot of times the person creating the LLC will say, well, I'll just be the stat agent. Well, that's fine. You can, no problem with that. But what happens when your real estate business takes off? You're like, well, I can move, I can buy a better house, right? And so you move, it's all great and whatever. Well, let's say that your LLC is being sued and they go to serve it and they show up at your old address because you didn't update it, right? You didn't update your address with the Corporation Commission. They go knock on the door at the old address and like, oh yeah, so-and-so doesn't live here. We've moved in a couple of years back. I have no clue where they're at. Well, the plaintiff doesn't have a duty to try to track you down. At that point, you haven't updated your address as statutory agent with the Corporation Commission. So guess what they get to do? They get to march down to the Arizona Corporation Commission, waltz on into their offices and say, hey, I'm serving this LLC through you. And they give it to somebody there at the Corporation Commission at the window. They give it to them and they say, oh, okay, thank you. And now you've served the LLC. Well, what's the Corporation Commission going to do? They're going to send it to the address.
The same bad address.
The same bad address. And then you never receive it. You don't even know. And then all of a sudden a default judgment's entered and you come back and you say, wait a minute, a default judgment's been entered against this LLC. I never knew about it. Oh yeah, you did. Because the corporation was served on your behalf because you didn't update your address. And guess what? That's a good service. And that default judgment's going to stand and you need to pay that money to whoever got the judgment against you or against not you, the LLC. So that's the problem in my view. And I see this over and over where I have clients who've moved and things like that. I'm like, well, why didn't you update? Well, so then we help them update and that type of thing. But I like using either a private, statutory agent where you pay them on a annual basis to serve as statutory agent. There's a number of them here in town that you can use, and they'll keep the information updated, and then they will work to connect with you. Even if you move, they're going to have your email address, your phone number, which normally never change, and they're going to connect with you and get the information over to you. Alternatively, a law firm. Most law firms will serve as statutory agent. Our law firm serves as statutory agent. Oh, and guess what? When we moved from Mesa to Scottsdale a few years back, how much time did we put in, and even money, because it was like $5 a pop, to change our address for every single matter that we, or LLC corporation that we served as statutory agent with the Arizona Corporation. We had to do that because, that's our exposure, our liability if we don't update that. So part of the moving process was having a staff member go and change every single one and make sure that our address was updated. Now, the downside is if we receive service of process, we bill our clients for the time it takes to, process that paperwork, to, track down the client, to, send it to them, that type of thing. There's a cost involved in that. But that cost is de minimis as in comparison to a default judgment that might be entered against the LLC.
Right. So everybody, it seems like everybody's talking about Wyoming and Delaware LLCs. Why are they talking about it, and should they be talking about it?
Yeah, that's a great question, and that is a hot topic. So really what a Wyoming and Delaware LLC, what they do that's different than here in Arizona is they offer basically complete anonymity. You basically file a one-page sheet with both Wyoming and Delaware that states this is the company name, this is the statutory agent, which is going to be a private company in either Wyoming or Delaware that you hire to receive service of process in those states. And you has the name of the person that's forming it. So it can be an attorney. So our office, for example, will sign as, the person, who's forming it on behalf of the client. And so we sign it. So when you go to Wyoming or Delaware and you look in their records, you just see the name of the company, the private statutory agent. So it doesn't identify, the members or the owners of the LLC, and the name of the attorney that formed it. That's it. That's all that's on file. So there's this level of anonymity that nobody knows behind the scenes who's the member, who's the manager, nothing. Now, the one thing though that I always state is that anonymity is not asset protection. You're protected the same, and you still have to keep corporate formalities, whether you form an Arizona LLC that doesn't have anonymity or a Wyoming or Delaware LLC that has anonymity. You have to do all of that. The only difference is that a injured party or a plaintiff or a creditor will know who's behind the scenes in an Arizona LLC as opposed to a Wyoming LLC. So it's a deterrent, but it's not asset protection. Asset protection is created in the corporate veil, and you can create that with an Arizona LLC, and you can create that with a Wyoming or Delaware LLC. It's more expensive to form a Wyoming and Delaware LLC because of the fact that there's more work to have it formed, less of an online process like here in Arizona. And then you also have to have an operating agreement in place for those, because you have to specify who owns it, who the managers are, because the form that you file doesn't specify any of that. And so you have to have that operating agreement in place by the laws of those states as part of the formation process.
All right, Mayu, I understand we have a few questions.
Yeah, we have just a couple. So I know that we talked about LLCs a lot today, but let's switch gears back into talking about S corps because we got some questions there. If you know, what are the requirements to, I guess, be structured and taxed as an S corp?
Yeah, so it's actually a very simple process. So there's I don't remember the name of the form or the number of the form, but it's basically a form that your CPA files with the IRS that basically states this entity is going to be taxed as an S corp. And now the thing is, once you make that election, you have to keep it for. Do you remember, Andy? It's a couple of years, right?
Yeah, you got to keep it for a little bit.
Yeah, and you can't go back. So, but once you make that election, it's like a 1 or 2 page form that you file. And then that's it. And then you file your tax return accordingly. So it's a pretty simple process. It's not complicated to change that tax filing status to reflect S corp status with the IRS.
Okay, so once you choose to be taxed as an S corp, you can't go back to being like a sole proprietorship or.
Yeah, that's right. So once you make that election, you can go back after a couple of years, but you have to operate as an S corp for a couple of years to go back. Our law firm, we were a partnership. I don't know that we ever went back, but we were a partnership for a long time. And then we went to an S corp. I don't know if we went back, but we've changed our tax status a number of times. And it's once again, just a real simple election.
Okay, well, last question then. This one is about It's kind of a lengthy comment. This one's about avoiding dealer status. If you know what that is, like the gray area in Section 1031 of the IRS code. It just differentiates between an investor and a dealer. I know you guys aren't tax attorneys, but so attorneys have suggested to structure a business so that real estate investor sales are ancillary to the core business, as in like making agent or the sales the core business. This isn't asking for tax advice, but maybe if you've had some clients that you're able to weigh in with some details on strategies that other investors are using to avoid that status.
No, I mean that's something that's kind of outside of our bailiwick.
Now they mentioned 1031, like a 1031 exchange. I'm not sure if that was
think that's right.
what the reference was.
Yeah, and so we'll handle transactions involving 1031 exchanges, but we always work with an exchange agent who processes everything. Sometimes we work with the CPA to figure out the proper structuring of the, entity that's going to now own the new property, those types of things. But no, we don't really get into that type of planning or advice, unfortunately.
Okay, last question.
Mhm.
What's the best way to transfer a rental property from my personal name into an LLC?
Yeah, great question. So if there is a lease in place, there's two things that you're going to want to do. So the first is you're going to want to transfer the property by warranty deed from your name into the name of the LLC. And then you're going to want to execute a real simple assignment of lease, whereby you assign the lease from your personal name to the name of the LLC. And then once you do that, you're going to send a notice to the tenant advising the tenant of the fact that the property is now owned by this LLC and that the lease has been assigned and that payment to be made to the new LLC. And of course, the LLC should have its own EIN and bank account. So it's not an overly complicated thing. So a lot of times people, for financing or other reasons, they buy it in their name and maybe even put a tenant in there and then they get around to transferring it. It can be done. Not 100% ideal, but it's, if you do it right, there's nothing wrong with creating that LLC and transferring it and assigning the lease. But I think it is critical to assign the lease, not just transfer the property.
That's right. Yeah. All right. With that, that is our episode for the week. Make sure to join us next week, Tuesday at 10 a.m. Arizona time. We're talking about strategies in managing short-term rentals. Our guest is going to be Andrew LeBaron. It should be a great show. Short-term rentals are a great and hot topic here in Arizona and multiple places. Look forward to seeing you guys next week. Take care.
Have a good day, everyone.